The hearing will come to order, and good afternoon to everybody. Thank you for being here. I would just like to make one introduction. Sue Kiley, who's the mayor, now deputy mayor of Hazlitt, and her husband, Gene, 3 decades on the police force, as well as number 2 there, is also with us today. I want to thank them for joining us. And would like to thank all of you for being at this hearing, which is one of a large numbers of hearings we've held on child abduction, and really pretty much a series on that. And of course, we will be focusing on this afternoon, the continuing and excruciatingly painful crisis of international parental child abduction and what the Trump administration can and must do to stop it. As many of you here today have experienced, international parental child abduction rips children from their homes and whisks them away to a foreign land, alienating them from the love and the care of a parent and the family that has been left behind. Child abduction is child abuse and continues to plague families across the United States and really around the world. According to the U.S. Department of State and their statistics, almost 800 children are today held hostage in a foreign country, separated from their American parent. Several hundred additional children join their ranks each and every year. If past is prologue, only 16% of these children will be returned to the United States. In 2014, Congress adopted legislation that I wrote, known as the Sean and David Goldman International Child Abduction Prevention and Return Act, Public Law 113-150, to change the status quo. Its template was the Trafficking Victims Protection Act and the International Religious Freedom Act, and on the former, I was the author of that. Frank Wolf authored the International Religious Freedom Act. And what we did was to come up with ways of holding countries to account and then prescribing a series of increasingly strong or stronger sanctions to try to change the behavior of offending countries. Since 2014, we have seen a reduction in new abductions of children, but not an increase in percentage of returns in ongoing cases. Despite the new legislation, the State Department has persistently refused to use the return tools contained in the Goldman Act as envisioned by Congress. Moving beyond letters and meetings, the Goldman Act is an enforcement tool for the Hague Convention on the civil aspects of international child abduction and leverage for return agreements with non-Hague countries. The Goldman Act takes the lessons, again, from not only other legislation, but from the successful return of Sean Goldman from Brazil and lays out actions like delaying or canceling of one or more bilateral working meetings or state visits, the withdrawal, limitation, or suspension of U.S. development, security, or economic support assistance, and extradition. To my knowledge, extradition has been used only once, and the other options not at all. The Obama administration said in the past that sanctions will not work, but in the one case where sanctions were employed by Congress, they worked. And they have certainly worked in other programs, both domestically and internationally. And frankly, all of our civil rights laws have enforcement that includes significant sanctions, and that has worked as well. The inaction by the Obama administration has been noted and challenged. On February 14th of 2017, 1 month into the new Trump administration's tenure, Japan's Minister of Foreign Affairs, Kishida, noted in the Diet discussion of abduction that, and I quote him, "Until now, there is not a single example in which the U.S. applied the Goldman Act sanctions toward foreign countries." He went on to note that, quote, "According to the United States, Japan is not included in the category of the non-compliant countries." In other words, no fear. Hasn't been used, will not be used, and Japan is off the list. 3 days later, the Osaka High Court overturned a return order for the 4 American children of James Cook, who will be testifying today, in flagrant violation of the Hague Convention, Japan's own Hague implementation guide, and U.S. law. The court has reopened the case because Mr. Cook has moved into an apartment after the enormous legal bills from years in court in Japan. When did sharing a bedroom with a sibling, and this is something that's become part of his concerns, become a grave risk to a child's physical or psychological well-being? It's not, and yet that now is being thrown in his face. I believe and I urge the new administration to do more on behalf of these parents and especially on behalf of these children. At least 300 to 400 children have suffered abduction from the United States to Japan since 1994, and more than 35 currently await reunification with their American parent. Most of these are left over from the previous administrations. In almost all cases, the child is completely cut off from contact with the left-behind parent. Most have aged out of the system without ever being reunited with their left-behind parent. And of course, then, that's a closed case. Some parents have won in court, only to find that Japan's law enforcement could not return their children unless the taking parent agreed to abide by the decision, and the taking parent did not. That is underscored in James Cook's testimony today. Find it. Certainly will make the point. And it's worth repeating what he will be telling us shortly. Numerous enforcement attempts have been made in Japan using all legal means of enforcement, talking about his own case, starting in February of 2016 through September of 2016. All attempts were unsuccessful. At the heart of Japan's enforcement articles for Hague is required voluntary compliance from abductor for enforcement. When an abductor says no, enforcement ends. In contrast, if we were to go to see our children in Japan without her permission, I risk arrest and being held for 23 days in jail before any changes need to be filed, after which I could be denied entry into Japan in the future. This is just one example, he points out, of systemic deterrence against left-behind parents attempting to have a relationship with their abducted children or effectuate foreign court-ordered returns. So enforcement, even when the courts do the right thing, enforcement stands out like the sword of Damocles and says, there's no way you're getting your child to come back. The systemic non-enforcement of access and return orders is so bad in Japan that 26 EU countries recently issued a joint démarche to Japan asking Japan to fix the problem. Although non-enforcement has plagued many U.S. cases, the U.S. did not join in that démarche. However, in the upcoming Goldman report, the U.S. has the chance, the opportunity, to hold Japan accountable for its failures in the Cook case, as well as so many others, like that of the Elias children, taken from my home state of New Jersey, after their mother obtained duplicate passports from the Japanese consulate in contravention of a judge's order in New Jersey. The report can and must better reflect the reality of the child abduction issue and the suffering of American children separating from their American parent every day in Japan. According to the Goldman Act, the country can find itself on the non-compliance list and eligible for sanctions if the country regularly fails to enforce return orders, like Japan. The State Department should also put the country on the list if the judiciary fails to properly apply the Hague Convention, as we have seen in the Cook case in the past. Finally, a country should be put on the non-compliance list if 30% or more of the cases in the country are unresolved or cases that have been pending for more than a year. Notably, the definition of an unresolved case makes no mention of a country's Hague status. In other words, all of the cases that began before Japan's accession to the Hague Convention and that were communicated to the Japanese government should be counted against Japan. No child should be left behind. We received assurances from the State Department years ago as they myopically pursued Japan's accession to the Hague Convention, knowing that the convention would not cover the existing cases, grandfathered out, of more than 50 children, that they would not leave these children behind, that they would find ways to resolve those cases. How many of these children have come home 4 years later? How many have even had access to their left-behind parent? Almost zero. The Goldman Act directed the State Department to develop an agreement with Japan for the precious children that were already abducted. The Goldman Act made a way for the State Department to hold Japan accountable for these cases. 4 years later, we have no agreement, no MOUs with Japan for these cases. We have no action against Japan for these cases or current cases. And we have yet to see the department even list Japan as non-compliant in the annual report. Every day these children are separated from the U.S. parent, the damage compounds. It's bad in the beginning, gets worse, then gets even worse. As the State Department's own 2010 report on compliance with the Hague Convention on the Civil Aspects of International Child Abduction observes, quote, abducted children are at risk of serious emotional and psychological problems. Research shows that recovered children often experience a range of problems, including anxiety, eating problems, nightmares, mood swings, sleep disturbances, aggressive behavior, resentment, guilt, and fearfulness. As adults, individuals who have been abducted as children may struggle with identity issues, personal relationships, and possible experience problems in parenting in their own children, with their own children, close quote. We must do better by our children. We must not leave any abducted child behind. Congress is currently looking at new ways to put pressure on countries with low resolution rates like Japan, Brazil, and India. Last year, I introduced H.R. 3512, the Bindu Phillips and Davenport International Child Abduction and Return Act of 2017, to amend the Generalized System of Preferences system so that any country named as non-compliant would lose their trade benefits. The loss of trade preference would be automatic and not dependent on the administration choosing to apply sanctions. Currently, 11 of the 13 non-compliant countries receive trade benefits from the United States. That has got to change. In addition, I'm working on a bill that would limit H-1B and other business visas for countries that have low abduction resolution rates. And again, that would affect Japan, Brazil, and India, among others. We have 13 egregious long-term cases pending in Brazil, including Dr. Brand and Davenport cases. More than 90 American children are separated from their American parent in India. India will not even appoint a person to receive the applications, and they have refused to join the Hague Convention. We asked in our hearing last year, when is enough enough? We hope that the State Department will do its job and implement the Goldman Act robustly. We hope the Trump administration will be different than the last administration. But we are prepared, so I would like to yield. Dr. Harris? For any comments you might have? Okay, we're joined by Dr. Harris of Maryland. I thank you for being here, Doc. I'd like to now introduce our first witness. We have two panels today, beginning first with Ms. Suzanne Lawrence, who is the new Special Advisor for Children's Issues, having assumed the role late last year. Ms. Lawrence has previously served as the Deputy Chief of Mission at the U.S. Embassy in Athens, Greece, and as a Senior Advisor for the Assistant Secretary in the U.S. Department of State's Bureau of Consular Affairs. Her career in U.S. Foreign Service has given her a wide breadth of experience to apply to child abduction cases, and we're very grateful that she's here and look forward to her tenure in office. And without objection, her full resume will be made a part of the record. Ms. Lawrence, the floor is yours.
Thank you. Thank you. Chairman Smith, other members of the subcommittee, thank you for the opportunity to speak about the work we do to prevent and resolve international parental child abduction. My written statement, which I ask to be entered into the congressional record, provides
Without objection, so ordered.
Comprehensive review of our accomplishments and challenges. I will highlight the most critical of these in my opening statement. Allow me first to take a moment to thank Ms. Patricia Appy and Mr. James Cook for their commitment to our shared objectives. I also want to acknowledge the parents who are here today and who work to resolve their cases with my colleagues in the Office of Children's Issues. I have had the pleasure of meeting many of them in the past 7 months. My colleagues and I are encouraged by the continued interest and support from the American public and from Congress. As we advocate on behalf of the children and parents affected by the heartbreak of abductions, congressional involvement and oversight are unique tools we can use in our diplomacy. The 1980 Hague Abduction Convention remains one of the best methods for resolving abduction cases. Over the past 10 years, more than 4,500 children have returned to the United States. Further, the existence of the Convention's return mechanism has deterred an untold number of abductions. And we are heartened to see the number of new abductions reported to the Department of State has declined by more than 60% over the past 10 years. Allow me to mention 3 examples of the effectiveness of the Convention. From 2014 through 2016, 95% of abduction cases to the United Kingdom, one of our biggest partners in terms of cases, closed in less than 1 year. In Mexico, our largest convention partner, more than 73% of abduction cases were closed within 1 year, and more than 340 children returned to the United States from 2014 through 2016. And in Japan, there has been a 46% decrease in reported abductions since 2014. There is additional detail on the convention's successes in my written statement, and these outcomes underscore our goal to encourage all countries to join and properly implement the convention. The Sean and David Goldman International Child Abduction Prevention and Return Act has supported our efforts to promote accession to and implementation of the convention. For example, since 2014, 7 countries that previously did not adhere to any established protocols to resolve abduction cases have acceded to the convention, and we are in the process of moving towards partnership with some of these countries. We have also welcomed 5 other countries into our community of convention partners, which now includes 77 members, committed to the shared purpose of resolving child abduction. In countries where the convention has not been embraced, we turn to other tools. Non-convention cases are extremely complex, and we work with left-behind parents, interagency partners, and foreign counterparts to resolve those cases. Since my arrival in September of last year as the Special Advisor for Children's Issues, I have traveled to The Hague, to India, to Japan, and to South Korea to personally engage in illicit cooperation. In India, I urged the government to find a resolution for the many abducted children located there and for India to join the convention. In Japan, I raised our concerns about the enforcement of convention court orders and also urged the government of Japan to find a resolution for the children involved in pre-convention cases. In South Korea, I addressed potential areas of improvement in their handling of convention cases and explored opportunities to strengthen multilateral efforts to advance the convention in that region. And at The Hague, I worked with the Hague Permanent Bureau and representatives from dozens of member countries to improve implementation of the convention around the globe. The Act has also bolstered our ability to manage a robust prevention program, which continues to be a key priority. In 2017, we enrolled over 4,000 children in the Passport Alert program, which is a 13% increase from the previous year. And thanks to the Act, the Department continues to meet biannually with the Interagency Working Group, which has had a daily direct impact on preventing abductions and has improved the U.S. government's response to combating abduction. In conclusion, Mr. Chairman, please be assured that the Act has significantly reinforced our work to address international parental child abduction around the world. We constantly strive to increase our effectiveness and always look for ways to collaborate with our partners, including you, members of Congress, who have committed so much time and energy to addressing this very important and urgent issue. Thank you, and I look forward to answering your questions.
Thank you so very much. If I could, Ms. Lawrence, if you could tell us, you said you raised with India and Japan, other countries, what was India's response when you raised it? When you spoke in Japan, not only about the Hague cases, since they have become acceded to it, but all the pre-Hague cases, the legacy cases. What was their response? What did they say they're going to do? And did you do it by name? Did you raise specific cases?
Thank you for that question, Mr. Chairman. I'll start with India. So I was in India in February, and I met with a number of staffers before I went to India to discuss some of the issues that we have had. When I was there, I was joined, of course, by the team at our mission there. And I know that that has been a concern previously to have our chiefs of mission, our ambassadors, engaged. And I can assure you that Ambassador Juster has taken this on board from the time he arrived to take up his responsibilities there through today. And he will continue to advocate on behalf of the families that are tragically affected by this issue. He had meetings with Minister Gandhi, who is the head of India's Ministry for Women and Child Development. And when I traveled to India, it was hopefully to build on some of the momentum that we felt the Indian government was showing with regards to accession to the convention, and also with a willingness to work with us on those pre-convention or the current cases. I met with a range of individuals. I was in Chennai, I was in Delhi. I spoke with the Attorney General for India, I spoke with members of the judiciary, I spoke with Minister Gandhi at the ambassador's residence. I spoke with opponents to the convention, proponents of the convention. It is an issue that we will not stop advocating for. We have engaged with, as you know, the Chandigarh Committee was the committee that the Indian government put together to investigate a recommendation that they would make to the Indian government about accession to the convention. We have spent several hours answering questions with the Chandigarh Committee. I spent another hour plus with the Chandigarh Committee via digital video conference, again addressing some of the myths that persist about the types of cases we're talking about, and also about what the convention actually means. So we did have a range of meetings. We had them at the highest levels of the government. Ambassador Juster has raised this at the highest levels of the government, and we are told that they are still considering accession to the convention. With respect to the cases that we have now, we have offered to the Indian government to sit down and meet on all of those cases individually. And again, in my conversations, I have emphasized that if we sat down and looked through all of those cases, that in and of itself would inform them of the scope of the problem and perhaps open up some areas where they could work productively to resolve some of these cases. Without the convention or any other protocols in place for these cases, the parents are left to pursue their custody of abducted children in the Indian courts. And typically, the resolution of custody cases in India has been slow. Indian courts generally do not order the return of abducted children to the United States. And in general, custody is given to the taking parent, and the parents are left really to pursue their matter in the court system, which has not been a very effective method. So that is the short answer of my time spent there. I believe you also asked about Japan. In my travels there, again, I will say that Ambassador Hegarty has also been very engaged in this issue. He has raised this issue at the highest levels appropriate to him in the Japanese government. I have myself met, I've been in this position for a little over 7 months. I've had 4 occasions to meet with the head of the central authority in Japan. And while, as I did in my opening statement, I have acknowledged that the number of cases has gone down since Japan acceded to the convention, and that we have a very productive working relationship with the central authority, there are still problems with enforcement of judicial orders. When you cannot enforce those orders, it undermines confidence in the system, and it does not bode well for the future of the convention with respect to Japan. So I met with, again, the central authority there. I met with the Ministry of Foreign Affairs to talk about the pre-convention cases. They are well aware of which cases those are. We meet regularly with them to review that they have the correct cases that we consider to be open pre-convention cases. And again, we are to some degree stymied by the fact, and I know the parents who are affected by these pre-convention cases are reluctant under the convention to even file an access case, because they also feel that in the instance where there might be a judicial ruling that would give them some sort of access, that the enforcement of that ruling also would be ineffective or not take place. So I have made those concerns known. The ambassador has made those concerns known. We also met with officials from the Indian Embassy and the Japanese Embassy here in Washington to deliver those same messages.
What's your take on the foreign minister saying that? How did the department respond to his comments that they're not going to be put on the list of non-compliant countries. There's been no enforcement, no sanctions meted out as they should be. When a country shows such a pattern of non-compliance, the decision to enforce it ought to be almost automatic. There can be mitigating circumstances, we all know that, but in Japan's case, they're gaming the system. And so your answer to that, and also Mr. Cook's comment about the required voluntary compliance from the abductor for enforcement to occur. When the abductor says no, he will write and say today, enforcement ends. That seems to be, I mean, I have to say, when the previous administration kept arguing that if they just signed the Hague, our problems will go away and the legacy cases would take care of themselves. There would be an effort, there'd be a goodwill that would be generated that would lead to resolution, and not resolution by way of aging out, so it's no longer a case that we look at. I traveled with Michael Elias's mother and father to Japan, raised all of these issues and said, look, to me it seems like the nose in my face, it's so stark, looking in the mirror, that you can't get away from it, that one, the past cases will be treated with even more prejudice than before if they sign the Hague, and that then when they get to enforcement, they're going to do it in a way that it's like Swiss cheese, and it won't happen. All of that has happened, and I'm not a prophet, but it seemed very clear from the conversations and from their past very quickly becoming prologue. So this idea of required voluntary compliance from the abductor for enforcement, to me, that is outrageous that a country, a great country like Japan, would use that kind of impediment. And that makes all the Hague cases, moot. It's going to be a voluntary, yes, you can have the children back. So why do you even need the Hague? Except for a nice backdrop to say, look, we've got a treaty and a convention. So if you could speak to those two. And again, when you talked about Michael Elias, is one of the concerns that many of us have had, and we have this with several of our left behind parents, as you know. These are military men and women who are deployed to Japan for the defense of Japan, at Okinawa, in Yokohama, and other places. And then their child was abducted, and then they ran into this buzzsaw of opposition from a government that if Japan isn't put on the non-compliant list this year, I can't tell you how egregious that will be not to see that happen. And then followed very quickly thereafter with serious sanctions. If President Trump, because Obama wouldn't do it, so let's lay that aside, and I found that to be outrageous. But if President Trump can levy sanctions on China and talk sanctions, NAFTA, and renegotiating NAFTA on economic issues, and if our aluminum industry and steel and other things are so important, and which they are, how about for people, for American children who have been abducted? That to me is in a class of its own, a league of its own, and there needs to be, if ever there was an America First, this looks like this is one of them. It's the children, it's their parents. So I would, appeal to you, because it starts with what your findings will be, and then obviously it goes up the chain of command as to what they finally do, but it seems to me it's a no-brainer. It's been a no-brainer. This year it's got to be.
Thank you, Mr. Chairman. We share your concerns, as I said, about Japan's failure to enforce convention court orders. And in many of my meetings, I don't only talk about the convention writ large or the issue of parental-child abduction, but I do take it to that personal level, as you have referred to. These are people, these are their lives, and people need to be reminded that for someone who has not seen their child in a day, a week, a month, years, this is a life or death matter. This is a very important, life-altering event, and we owe it to all of these children, all of these families, to continue to press where we need to press. When a Japanese parent, taking parent, refuses to comply with a return order, we have found that Japanese authorities have very limited means to enforce the order. And we have worked to broaden the discussion to different parts of the Japanese government, but it will require some changes in their domestic legislation to give law enforcement the kind of power you're talking about in terms of enforcement. And we have raised our concerns about enforcement failures at the highest level. This year, the relevant entities across the Japanese government have heard our call to take a whole-of-government approach, and they have brought others to the table. And we have had a chance to talk to those agencies about the needed legislation to improve their enforcement of court orders. With respect to citations, we can't, of course, discuss the individual country citation before we give the report to Congress and it's published, but I can assure you that we have had a number of conversations about how those decisions are made. And enforcement of convention court orders is a component of the Hague Convention. Your compliance with the convention also depends on your enforcement of court orders. And the department will most certainly take into account Japan's enforcement failures in this year's ICAPRA report.
Patricia Appy, who was the brilliant lawyer who was the lawyer for David Goldman, the American lawyer who just did a wonderful job in helping to make his reunification with his son, Sean, possible. She's testifying today, and in her comments, notes, and I would appreciate your reaction to this. Prior to the enactment of the treaty, this is regarding Japan, parents who had pending abduction matters were sent from time to time urgent, time-sensitive updates, repeatedly promised that the Hague ratification would enable them to at least secure access to their children. The promises were entirely illusionary. Now, those memos came from OCI. And I'm wondering if you know, how do you respond to that? I mean, here's what the parents tell me, and I meet with so many of them. They get frustrated. They know that there are good people working. You and the others are wonderful people, but you do have the tools now with the Goldman Act, and it seems like those tools stay in the toolbox. But you know, here we were just talking about access here, not even reunification, and you know, bringing those children back home. Your thoughts on that?
Thank you, Mr. Chairman. We have already discussed a little bit about the pre-convention cases, but again, we do continue to work with the parents who are, there are approximately 20 pre-convention cases that remain active, and we work with the left behind parents to see which methods or avenues they might have available to them. As I said in my written statement, approximately half of those left behind parents have achieved some access. It's limited. Sometimes it's a Skype call. Sometimes it's an exchange of letters and gifts. We know of one parent who has had an in-person visit. Going back to what we just spoke about, if you're a parent and that's your child, is that adequate? That is not adequate. However, we continue to press, again, on this enforcement issue because I think a lot of parents are put off by the idea that even if they pursued an access case under the convention, their sense is there may be no effective mechanism to enforce the court order for access. And so, again, what I'm saying to you here about access, about these parents, about their disappointment, is what I have said to Japanese officials, and we will continue to say that. And I appreciate your support in carrying that message forward.
Well, again, putting Japan on the list and then enforcing it with sanctions will send a message that none of our words can possibly achieve. So that the foreign minister, so that the prime minister cannot in their meetings, or even as he did before the Diet, claim accurately that there's been non-enforcement and they're not on any list. I can't stress that enough. It would be negligence of the highest degree to leave them off the list, given their track record, which is abominable. I mean, if this were reversed and the U.S. was doing this, I could tell you I'd be holding hearings on that and pressing our own government to, you know, in the sense of reciprocity and good governance to hold ourselves to account. And, you know, what we do in not putting them on the list has bearing with what the judges will do when they get a case before them, they'll say, well, I guess Japan's not so bad. And what's your sense on that? If so it's not only, the risk factor to a potential abduction is very high if the judges get the wrong information about a specific country, including Japan.
Thank you, Mr. Chairman. I've had a lot of opportunity to consider the efficacy of the report in and of itself as I travel around, as I meet with other countries. And it's a really powerful tool. The convention is a powerful tool. The report is a powerful tool. As far as I'm aware, we're the only country that produces a report like that. And I know what you mean by sanctions, but I can say that in my meetings, very often, the foreign counterparts will bring the report up. And I agree with you that the citations in the report can have very positive effects in terms of the actions that a country will take. Sometimes it takes a while, but I do think that the report is an extraordinarily valuable tool, and for some countries, they believe they are being sanctioned by having the citation in the report. And of course, beyond the citations, there are narratives in there that really talk about performance, and countries are very keen to see how that will be characterized in the report. So I do believe that we have some tools at our disposal that are very meaningful to these countries.
Ms. J-Bell.
Thank you, Mr. Chairman. Thank you for having me here. Thank you for having this hearing. And I want to thank you for your years of work on this important issue. I think we all understand that there are many of us that are deeply concerned, and we're grateful to the State Department for your efforts over the years. And I want to especially just recognize the families in the room, that some of you have traveled. I know as a mother, I cannot imagine the pain of what you have gone through, and I want to thank you for continuing to be here and continuing to push for us to resolve these situations, to bring children home to their safely and to their loving families. I was introduced to this issue. I'm new to the issue, but I was introduced to it by my constituent, Jeffrey Morehouse, who has been fighting for the return of his kidnapped son, Mochi, since Father's Day of 2010. And that was the last time that Mr. Morehouse saw or heard from his son. And despite having custody of his son under Washington state law since 2007, a mutual agreement with his ex-wife that she would not travel outside of the state or get a passport, an agreement that the United States is actually Mochi's home country. That was all outlined in this agreement. And the jurisdiction for any custodial dispute. Mochi was still abducted. And Mr. Morehouse even took the preemptive step of notifying all of the Japanese consulates and their embassy in the U.S. in writing that he was the custodial parent, and requested that they deny any request for a passport for Mochi. However, in June of 2010, as you may know, his ex-wife was provided a passport for their son by the Portland consulate, so he went over our state's border into Oregon. He was provided a passport after being denied one by the Seattle consulate, and in 2014 and 2017, Mr. Morehouse then went and actually defended successfully his custodial rights in Japan, where the courts ruled that his U.S. sole custody order is legal in Japan. His ex-wife has twice been denied custody rights under Japanese law, and during proceedings, she admitted to committing passport fraud and forgery in order to abduct Mochi to Japan. Mr. Morehouse is the executive director of Bring Abducted Children Home. He's come to Washington, D.C. over a dozen times on his own case, and the more than 300 U.S. children that have been kidnapped to Japan since 1994, when the Office of Children's Issues was formed. And yet, for nearly 8 years, he's been shuttling back and forth between Seattle and Japan, all in vain. And there have been some small victories, but really nothing that has resulted in him actually reuniting with his son. And so I just wanted to follow up on the chairman's questions, and I apologize if you said some of this before I walked in the room, but my understanding is that we have provided in the Goldman Act a number of steps that can be taken. And obviously the first of that is, using the diplomatic channels, but there are others, and they go all the way up to formal request to the foreign country to extradite somebody, but there's other things around an official public statement that details the unresolved cases. I guess that's our report. I don't believe we've done a public condemnation in any of these situations, but perhaps you can educate me if we have. And I guess it seems clear to me from reading these, and I'm, as I said, new to the issue, but it seems clear to me that voluntary is not going to produce the results we're looking for. And that we can continue using diplomatic channels, and we should, but we have provided other tools here for the State Department to utilize. And so I'm just wondering what brings this issue to the threshold where, because we've already crossed the thresholds that are outlined in the Goldman Act, as I read it, and so what can you do differently to ensure, for example, that Japan is going to reunite Mr. Morehouse's son? Because my deep concern is that the more these different countries see that the United States is not using the tools, the easier it gets for these countries to continue to just say, well, we'll just work through diplomatic channels, which really means nothing would move forward. And so if you can just help educate me about how you see that, what is the threshold to move from one step to another within the tools that we've given to you? And what can we possibly tell our families about what we're going to do differently than what we've been doing? Because clearly that has not produced the results we're looking for.
Thank you, Congresswoman. Again, with respect to Japan, as the chairman has pointed out, we pursued their accession to the convention. Mr. Morehouse's case is clearly pre-convention. And we have seen a result since they acceded to the convention in terms of a reduction in the number of reported cases and a resolution to the 2014 and beyond cases. We have actually, as a central authority, filed 18 cases with the Japanese Central Authority, and we have had resolution in 14 of those 18 cases. These are convention cases. Most of those have come through this voluntary mediation process. Again, we understand that enforcement of judicial orders is a failure, and it is something that we continue to work on. The Central Authority doesn't have, it seems, the power or authority to make changes that would make enforcements work, which means we've had to ask them to bring other people to the table. We do consider all the tools we have at our disposal, and we do that with our interagency partners and try to use the best tool at the best moment on a case-by-case basis. I hear your concerns about the use of the other tools, and we continue to speak with our interagency partners and the rest of the department who clearly have interests in our bilateral relationships with many of these countries, Japan included, and we know that we have those tools at our disposal and consider them when we think they will be effective.
So what would move the threshold in order to use those tools? I'm still not clear on that, because I understand you're discussing with other agencies, and maybe you could describe that a little bit more. Which are the agencies and departments that you routinely work with, and are there some that have not engaged that need to be engaged? But I'm just trying to understand what would be done differently now that has not been done before, because it's very difficult for us to go back to our constituents who actually have gone through everything that they could possibly go through, both here in the United States and in some cases in the country where their child has been abducted to. What more do we need to do to ensure that you utilize those tools and cross that threshold from just pure diplomatic advocacy? And I just want to echo and recognize the work that you all have done. I think you have made tremendous progress in a number of places, and particularly on those post-convention cases. But I feel like some countries are hiding behind that specific date, and we're not getting resolution.
And again, I think, Congresswoman, that from many countries' point of view, citation in the report would be considered a serious step, and it has resulted in some profound changes in many places. As I said, we wouldn't be able to talk right now about what citations will appear in this upcoming report, but we have had a number of conversations with our Japanese counterparts explaining our frustration with the lack of momentum on enforcement of orders. And in the case of Mr. Morehouse, because I've had the opportunity to meet with him a number of times, we have the characterization of the history of his case is something that we have directly spoken with them about. Again, we do our best to use the tools at our disposal. I don't have a specific answer for you on what the threshold is. We are one voice, one part of the conversation, and I will take back certainly the frustration from members of Congress on not utilizing the full range of tools. And we do feel that we are getting results from a lot of our engagement, certainly from the annual reports, and certainly from the engagement by our chiefs of mission, including Ambassador Hegarty. They are the President's personal representative in that country and the chief of our bilateral relationship with that country. And I think their voice on these issues carries an enormous amount of weight. So we are working in the avenues that we think will produce the best results. And I take on board your point that you believe that there may be results from the use of other tools. At this point, the tools that we have employed and continue to employ have shown some results.
You mentioned earlier that Japanese authorities, I think I wrote this down, Japanese authorities have very limited means to enforce the orders. That seems to me to be, if they're saying that, I think it feels a little, perhaps not fully forthright, that there are many more things that could be done. And it seems to me that if they need to hear that this is critically important to us, that's where that list of tools, and I don't want to continue to harp on this point, but I just think that at some point we need to move down that list. Otherwise, the act is not really being implemented the way I think the chairman and others had envisioned when we put it into place, because it is working on some, but I think we need to really look at that whole piece. And I hope you hear our frustration in not seeing, particularly on certain cases that have been in process for a long time, not seeing any results there and not having anything to advocate for our children.
Thank you again for that question, and also for expressing that level of dissatisfaction with the progress to date, because it is useful when we sit down and talk about the lack of enforcement. Again, I think when the United States government was pursuing Japan's accession to the convention, we understood that there was quite a gulf in terms of the cultural norms and the way in which Japanese society viewed custody. And we knew that there would be a period of adjustment. When I say law, the Japanese Central Authority or the Ministry of Foreign Affairs is limited, and also law enforcement is limited. It's the perspective of how they carry out these kinds of judicial decisions. And we have spoken about that, and I think the chairman referred to a letter earlier that a number of the EU countries sent. Again, there's nothing in existence, even in their domestic law, about these kinds of enforcements of judicial decisions with respect to custody that are useful at this moment. And that's why we continue to implore them to look at ways to put into place domestic legislation that would also have an effect on these international cases. And it's something that we continue to talk about and raise at every opportunity. So thank you again for sharing your perspective with me and your frustration on that level. It is helpful when we are talking to our counterparts to explain that this is felt throughout the U.S. government, and it is on behalf of our citizens and your constituents that we bring these matters to their attention and ask that they do something to resolve the problem.
Thank you, Mr. Chairman. I yield back.
Jay Powell. Let me just note for the record, and I know you know this, Jeffrey Morehouse has done it by the book. He is so disciplined, like so many of the left behind parents, dotting every I, crossing every T. He testified in May of 2015 before our subcommittee. Very, very comprehensive testimony. He remains, so thank you for raising his case. The idea, and I'll go to Dr. Harris in 2 seconds, you know, as you may know, I'm the author of the Trafficking Victims Protection Act. That has sanctions in it. When Israel and South Korea, two of our closest allies, were deemed to be Tier 3 egregious violators on human trafficking, they were worried about security assistance and other assistance, but particularly security assistance, being limited in some way. They changed their laws. They enforced, in the case of Israel, existing law, and they shut down the brothels and came into compliance within 1 year. Sanctions work. And if Japan, you know, doesn't get it through your persuasion, and I thank you for trying so hard, it is time to lower the boom, please, with respect, and say you have failed utterly. These longer-term cases are egregious. These families are broken, and security assistance, as you know, in the Goldman Act is one of those sanctions that can be levied upon a country. Dr. Harris.
Thank you very much, Mr. Chairman, and thank you for giving me the opportunity to be at today's hearing. And Ms. Lawrence, thank you for the work you do, because, you know, there's some things where Americans have to look to the federal government as their one and only hope. There's just some issues that the federal government is the only thing that's going to solve their problems, and this is one of those issues. So, we probably, you know, move a little broader than just Japan, but obviously the Goldman Act lists a series of escalating actions that the State Department can take when international child case, abduction case remain unresolved. But I'm curious just to run down some of these things to see if, you know, what tools in the toolbox have been used. Has the State Department canceled or delayed any state visits, bilateral working groups, or other official visits in response to any unresolved abduction cases in any country? Because that's one of the tools in the toolbox. And that, you know, that seems like a pretty simple tool, because some of these nations, I think, need a bilateral working relation. So has the State Department done that in any case?
I've looked through the list of tools. Thank you, Representative Harris, for raising that. I'm sure that there have been some meetings or other events that may have been canceled, but I cannot speak to the fact if they were canceled indirectly related to the issue of international abduction. So I would have to go back.
If you can get back to me, that's fine. And, you know, I sit on the Appropriations Committee, so, you know, we want to make sure that American taxpayer dollars are spent appropriately and according to the law, including the Goldman Act. So has the State Department limited or suspended U.S. development assistance in response to any unresolved abduction cases since the Act was passed 4 years ago?
I am not aware of us having used that particular aspect of the Act.
Okay. How about foreign assistance?
Again, I am not aware of any instance where we have suspended foreign assistance in relation to the Act.
Okay, even though you clearly have the ability, because and the Appropriations Committee has never, you know, said you have to do it, but you've had the ability over the years, right?
Correct.
What about security assistance, which I think the chairman has spoken about in terms of Japan, but there are other countries where that's important.
Again, I am not aware where we have used that.
Okay. The reason I'm asking that is because one of my constituents, Stanley Hunkovic, has been fighting for the repatriation of his children since 2011. It's a case, by the way, that's mentioned in your annual report. His children, Gabriel and Anastasia, are American citizens who were abducted by their mother, Leah, and they are currently wards of the state in Trinidad and Tobago. So the issue of noncompliance with orders is kind of rendered moot because they're actually wards of the state. Now, he's not been able to see or speak to them in years, and until very recently, the State Department could not even confirm the children's whereabouts, much less their well-being. And that's despite the fact that, again, the Goldman Act's been in place for going on 4 years now. Can you commit to me today that the State Department will use any and all means at their disposal to pursue the return of any and all abducted American children, including Gabriel and Anastasia Hunkovic, from any country to which they've been abducted, including Trinidad and Tobago?
Thank you, Mr. Harris, for that question, and thank you for your interest in his case. I know that several of my colleagues will be meeting with you later this afternoon to discuss with you the latest developments in that case. Of course, this is a pre-convention case. Trinidad did join the convention, and we have had a productive relationship with them, which of course does not take away from the pain that your constituent has expressed to you as he has worked through this very difficult situation. I absolutely will pledge to you that we do look at all the tools available. We will continue to consult with you. We will continue to consult with our interagency partners, with all of the stakeholders in the Department of State, and use the tools that are most appropriate to get the best result.
Well, let me, and thank you for that. Yes, I have met with people who, months ago, and there's still no resolution. Of course, pre-convention is irrelevant because the Goldman sanctions apply to that case, regardless whether it's pre-convention or post-convention. Am I correct in that assessment? So that makes no difference whatsoever. And these children, it's now 7 years since they're abducted. They are wards of the state. The state actually has the legal authority over them. So I just don't understand, and again, I can see where compliance with orders and things like that are different in other cases. In this case, Trinidad and Tobago has the ability to decide what's best for this children consistent with international law, and have not. So is it going to take literally an act of Congress and an appropriations bill to get you ramped up through the escalating sanctions that can occur in some of these countries that the State Department has been unwilling to pursue, despite, again, this is a 7-year-old case. You can only bang your head against the wall so many times till you realize you got to try something else. Is that what it's going to take? I mean, I'd like to think the State Department is going to use the tools in the toolbox, but honestly, we've gone down the list. Canceling state visits. That's not. I mean, I know it's something that would get someone's attention, but you said you're not sure if that's ever even been done. These are serious cases, and I'm sure the State Department takes them seriously, but I'm not sure you use all the tools. And, I mean, we have the same tools, to be honest with you. I mean, we can limit anything we want to do because these are American taxpayers. Is that what it's going to take, or are you really honestly going to say, look, we're going to look at cases like this, 7-year-olds, wards of the state, we've tried everything with Trinidad and Tobago, 7 years gone by, that developmental assistance that you've been getting from us, which I'm sure goes a long way in your country, or that foreign assistance, or that security assistance, I guess you just don't need it.
Thank you, Mr. Harris, again, for bringing attention to this case in this venue. I know that my colleagues look forward to speaking with you a little bit more deeply later this afternoon to go through whatever options might be available to Mr. Hunkovich. It is a long time, as we've said before. These are not just issues, they're people, and they're their children, and it's their lives. And we take that with us every time we go into these meetings. I know that you have had conversations with our embassy there. I know you've had conversations with our office in the Western Hemisphere Bureau. I know you've had conversations with my colleagues in the Office of Children's Issues. We are all working together to try and find a way forward, and I hope that we will find a way to help resolve this case. It has gone on too long.
I couldn't agree more. I thank you. My point is, I guess it may be time for conversations to end. And again, if we need to apply the tools that the State Department is unwilling to apply, I'm more than happy to do it for Gabriel and Anastasia. And with that, I yield back.
Thank you so very much. Just a few follow-on questions, and I know Ms. Jayapal has some additional questions as well. As you know, India is the country with the most long-standing abduction cases in the world, has for many years been unwilling to join the Hague Convention. Close to 100 American children there are denied access to their American parent and suffer years in India's family court system. We have numerous left-behind mothers in the United States who suffered both domestic violence from their husbands as well as abduction of their children to India. Rushika Abe and Dr. Samina Raman are among them. They continue to suffer for lack of a resolution mechanism in India. Earlier this year, H.R. 3512, as I mentioned in my opening comments, was introduced. So to remove countries like India from GSP benefits until India begins to work cooperatively to resolve the abductions. Do you think an additional bill might, to limit India's H-1B visas until abducted U.S. children are returned, would also be helpful?
Thank you, Mr. Chairman. Thank you for mentioning the mothers who are left behind parents. When I was in India, again, part of that narrative and part of the effort to unravel some of the myths surrounding international parental child abduction is that the taking parent is always the mother. And as we know, there are a number of mothers who are the left behind parents. So that was in part, as I suggested, would be a useful lesson in going through all of the cases one by one to start looking at what patterns are really there. I think what you will find is that the pattern is that people know that they have a safe haven, and we have made that known. And I think the only way out of this, as we have said, is to at least accede to the convention. I know we've discussed this with respect to Japan. It won't cover the pre-convention cases in terms of returns, although there would be an access issue. But in the meantime, to find a mechanism, whether that's a memorandum of understanding, whether that's a working group, we put all of these things at the table. We advocated for them. I think there is a lot to be gained by sitting down and looking individually at these cases and seeing what more can be done than to force the left behind parent, whether it's a mother or a father, into the Indian court system where they are not going to see a resolution. So, again, I hear the range of tools that you are talking about. We are willing to sit down and talk with you about what your ideas might be. I don't know if our colleague from the Indian Embassy is still here. He was before. I can't see out the back of my head. But I hope that he has also heard a lot of these comments and will take that back to the embassy today.
And Bindu Phillips from just outside of my district has a very similar case. Her husband not only, and the local police have reported this accurately, not only did he steal, she tried to visit her children. It was not a good experience. We're very concerned about this, and if India is again not on the list, which I believe it will be, there needs to be a sanctions regime. I can't stress it enough. We do it to our best friends in trafficking. We can do it with our best friends when American children are abducted. Let me ask one final question. Nico Brand was abducted to Brazil 5 years ago by his mother, Marcel Guimarães, with the help of her parents, Carlos and Jamia. In February, the parents were arrested in Miami, as you know, and then indicted by a federal grand jury for international parental child abduction and conspiracy. They now face 8 years in prison if convicted. But Marcel, a dual U.S.-Brazilian national, remains a fugitive at large in Brazil with Nico. Under the Goldman Act, the Secretary of State has the authority, as you know, to ask for her extradition. While Brazil's constitution forbids the extradition of Brazilian nationals, Brazil could denationalize an extraditor, just like they did in another case this year involving a dual national who was indicted for allegedly murdering her husband in Ohio. Given this precedent, will the U.S. now request that Brazil denaturalize and extradite Marcel Guimarães to the United States to face similar criminal charges?
Thank you, Mr. Chairman. I haven't had the opportunity to let you know that I'll be traveling to Brazil in a couple of weeks, and many of the issues that you've raised about Brazil will be on our agenda. Of course, as you know, a request to return a child under the convention is separate from the filing of criminal charges against a parent. And criminal charges are not generally initiated in order to influence the outcome of the civil matter.
But as you know, it's already been done towards the grandparents.
And we remain in contact with the Department of Justice, and I would have to defer to the Office of International Affairs there to speak on extradition because they do have the lead on extradition.
Could you make that request?
We will
or at least an
certainly-
inquiry as
We
to
will
whether or not this
certainly,
process can be followed?
follow up with the Department of Justice on this particular case and the issue more broadly and get back to you, of course.
Ms. J-Powell.
Thank you, Mr. Chairman. I just wanted to, I forgot that I wanted to raise, and perhaps the chairman did in his opening statements, but the statements of the Japan's Minister of Foreign Affairs, Fumio Kishida, who observed recently that, and this is his quote, "Until now, there's not a single example in which the United States applied these actions," and he's talking about the Goldman Act sanctions, "towards foreign countries." And then he went on specifically to note that we had not labeled Japan as non-compliant. And 3 days later, the Osaka High Court overturned a final return order for Mr. Cook's 4 children. And so I just wanted to reiterate that and ask you how you read that comment, because to me that comment goes back to what I said in my opening statement, which is that we're not being taken seriously. Nobody thinks that we're actually going to do anything with the tools that have been provided. And I think that's extremely harmful, because I do think that it also affects what happens in these courts around these cases in these various countries. And so I'd be interested in how you read that comment, and what do you see as the remedy to the idea that the United States is not actually going to do anything about these cases.
Thank you again, Congresswoman, and thank you for raising Mr. Cook's case. I know he's on the next panel, and again, in his case, he did everything right. So again, we have made that point to our Japanese counterparts. I don't know the context with which the foreign minister spoke. I don't know why he chose to say what he did. I'm not going to answer on behalf of the Japanese government. I will leave that to them. What I can say is that when we have discussed their failure on enforcement and the shortcomings in terms of compliance with all aspects of the convention, we have discussed citations, we have discussed the full range of tools available. And I think there are many people that I have met with, certainly that Ambassador Hegarty has met with, that we have met with here in Washington, who do understand the severity of what we're talking about. So again, I can't answer for that comment specifically. I don't know why that comment was made or in what context, but I can say that the people that I have met with have heard our message. And again, I thank you for this time to speak about all of this openly and publicly. I think in my almost 3 decades of serving the United States and working as a diplomat both here in Washington and overseas, we are most effective when we speak with one voice and when people know that we are serious and together on the issue. And so I appreciate the opportunity to have this dialogue and hope that this will reach some of our colleagues so they understand the seriousness with which members of Congress view this issue. Thank you.
Thank you, but I think I know why he said that, because it is true that Japan has not been designated as non-compliant. Do you think that there's a high likelihood that Japan might be designated as non-compliant?
Thank you. Again, as I stated earlier, and I think I've said it a couple of times, I have been very clear with the head of the Japanese Central Authority and with all of the people that I have met with who have told us all of the things that they have done as a central authority and as a country to be a good partner under the Hague Convention and also to address pre-convention cases. My response has been, we appreciate the development of the Central Authority. We appreciate whatever they have done to be a good partner. However, when we are looking at the full measure of their performance, we must take note of the fact that they cannot enforce the court orders. And what we have said previously, and that gets to this comment, is that it undermines the confidence that people have in their seriousness with which they approach the convention. And so again, there's no mistaking what we think about that aspect of their performance, and hopefully they understand where we are.
Thank you, Ms. Lawrence. I'm going to yield back, but I do think it also undermines our credibility and our seriousness. It's not just the Japanese government's seriousness, it's the United States' seriousness about how we approach these cases. And so I recognize that yours is a very challenging position and a very difficult job, but I think what you're hearing is we would like to see our seriousness reinforced around these cases. We'd like to bring these children home, and we'd like to make sure that the governments that we're interacting with understand that we do mean that.
Thank you, Congresswoman. We have many shared objectives.
One just final question. As you know, we've talked a lot about enforcement or the lack thereof in Japan. Another threshold for a country being found non-compliant is judicial decisions inconsistent with the Hague Convention. As we will hear from Mr. Cook later today, next, the courts in Japan reversed the final return order in his case because they thought it would be bad for the children to live in an apartment in the United States. Do you believe this public decision by Japan is consistent with the Hague Convention's exception to return, Article 13b, grave risk of psychological or physical harm, or an intolerable situation? How Japan's de novo's best interest determination here affects future cases? I mean, it's an awful precedent, but I'd appreciate your thoughts and response.
Thank you, Mr. Chairman. I think that one of the areas that we work on very carefully is education through seminars, through workshops, through exchanges of information through our Hague network of judges. We have had many discussions with many partners about the exceptions in the convention and the use of those exceptions. Again, I think Mr. Cook did everything he could in the correct way. And so we do look to improve always the consistency of the decisions over time and the application of the convention. That's the purpose of the convention. And I also would mention, because this case has gone on for some time, that the purpose of the convention is to bring a quick resolution. It's to return the child to the country of habitual residence unless the case falls within those very, very specific exceptions. That's the purpose of the convention. As you mentioned at the outset, time is not a good thing in these cases. This is not to our advantage for the child, for the family, for anybody. And so, again, we're looking for application of the convention, correct implementation. We're looking for speedy results. That is in the best interests of all the people involved in these tragic circumstances. And so I have heard your concerns, and we share your concern for...
But publicly on the issue of living in an apartment, and the only reason he lives in an apartment is all the money he has spent in adjudicating this case, paying the lawyer's fees and everything else. So, you know, he's been drained by the process, and now that's used against him by a court in Japan. Do you find that outrageous?
As I said, Mr. Chairman, Mr. Cook did everything he could,
But it's not a viable
we have pointed that out
point
to...
for Japan to take, is it?
Correct. We went and talked specifically about this case as well. Again, we're looking for consistent implementation of the convention, which will give people confidence in the convention, and that's to everyone's advantage. And again, these should be speedy resolutions. The children should be returned to the case of to the country of habitual residence, and the courts are the place to properly decide custody of children. It is not a unilateral action by one parent. That is not the way to do this. So thank you again for those comments, and that will be helpful to us.
Just for the record, could you tell us how many cases were resolved last year in Japan?
I don't have the exact number. As I said, I only have a number from when they acceded to the convention. We, as I said, had filed 18 cases officially.
And how many children does that?
And I don't know the total number of children affected, but 14 of those cases were resolved. Again, they were resolved through voluntary means, perhaps mediation. None were resolved through enforced court orders.
None were resolved, so. Again, all the more reason why Neon Lights of Japan isn't on the list. I remember in a journalism class, the first one I took, and I wish it was followed by many of our journalists today, was the 3 A's of journalism: is accuracy, accuracy, accuracy. Get the book right. I mean, what we do in terms of what you do, because you do have discretion in terms of following the prescribed potential sanctions, you know, reasonable men and women have to decide what is the best way to get from here to there. But I'm just stating the clear truth with the backdrop of the Goldman Act as the criteria. I don't see how Japan can be anywhere but as non-compliant. Thank you. I appreciate your testimony and your service.
Thank you very much.
I'd like to now welcome our second panel, beginning first with Patricia Appy, internationally well-known expert and attorney practicing international and interstate family law. Among many countries in which she has litigated, been an expert witness, or served as a consultant on international family disputes are the United Kingdom, Brazil, United Arab Emirates, Italy, Pakistan, Australia, India, Japan, South Africa, Israel, Lebanon, and Canada. She is frequently sought out by both family law attorneys and litigants nationwide to serve as an expert co-counsel in their own state courts on international matters. Notably, Ms. Appy is an attorney, was the attorney for David and Shaw Goldman, successfully resolving the 5-year abduction case with Brazil, with Sean's return to the United States in 2009. Ms. Appy consulted very broadly with us, provided expert counsel while we were writing the Goldman Act, and I am forever grateful to her for that, which passed into law and is now the subject of part of this implementation hearing. I would also like to introduce Mr. James Cook, as the father of 4 children, 2 sets of twins, who were abducted and are in Japan. At this time, he has only been allowed 1 visit with his children and has not been allowed any access to them since August of 2015. Mr. Cook works for Boston Scientific Corporation, a manufacturer of medical devices in Minnesota. Mr. Cook testified before this committee twice during his ordeal, beginning with the State Department, appealing to the State Department to take action. Ms. Appy, the floor is yours.
Thank you, Chairman Smith and distinguished members of the committee. It's a privilege to return my first testimony before the subcommittee in support of the Goldman Act was actually in 2009. So I've been living with this act and its implementation, particularly in the context of private practice, since that time. I would respectfully request that my written statement be included in the formal record.
Without objection, so ordered.
Thank you.
Mr. Cook as well.
I had the opportunity to listen to the prior testimony, and I think it would be most helpful if I address some of the issues and the questions that were raised at that testimony from a practical perspective. The very first thing that I want to say is that the work of this subcommittee which went on for a number of years with extensive hearings, with a great deal of work, created an act which has had an immediate impact on the prevention of child abduction. The report that is a strong part of the act was actually opposed by the United States Department of State along with the body of the act when it was originally proffered. The opposition was that it would not be effective, that it would be met with a response diplomatically that would not foster the return of children, that it was not consistent with the Abduction Convention. All of those criticisms proved to be untrue. In fact, the number that you've been given for the reduction in the amount of cases of child abduction is a direct result of American judges who have had the opportunity to review the report and to make a determination when they're asked by individual parents for preventative measures, to make a determination objectively based on that information as to whether or not there exist obstacles to recovery of children systemically in a country. This is without necessarily consideration of the individual characteristics of the parties. So, for example, if a judge is looking at a report and it indicates that there is a non-compliant state, the judge then knows that there needs to be a broader and more protective aspect of parenting and access protections, which is why language is so important. One of the things that concerns me about the report and concerns me about the testimony that we've heard today is that language has been used very loosely. And I want to point out some of the places, so that this committee can appreciate it and consider it in some of the questions that have been raised and some of the legislative actions which may need to be taken. First of all, you keep hearing the word resolved. Cases are resolved. Let me remind the committee that under the convention, if we're talking about convention cases, there is one remedy that is provided with respect to an abduction, and that is return. The Hague Convention does not address custody. It doesn't address jurisdiction. It addresses the return of a child wrongfully removed or retained outside of the child's habitual residence. With respect to the organization of rights of access, there is one remedy. It is that there is an identifiable opportunity for actual access between a parent and their child. In the reports that went along with the original identification of the organization of rights of access, access was supposed to be the ability of a child, for example, to return and visit the other country of the parent, whether it's a left-behind parent or a parent in a case in which the parties just live in other countries. That's not what you're hearing in either the testimony or in the reporting. When you hear resolution, a careful follow-up question is, how many returns have there been? And the answer is, there have been none. When you're asked how many, there was a reference to half of the cases that were filed when Japan ratified the convention, providing an opportunity for access. The careful follow-up question, and I believe I did hear some response to this, is that the access that provided is not an identifiable access order. It might have been one Skype call. They're including in the definition of access the ability to send packages to a child without any contact whatsoever. Nothing in the convention contemplates that as access. So the first piece that has to be addressed is that the report has to be accurate, because an American judge has to know that, in fact, there is no ability to obtain an access order. If a child is retained in Japan, for example, there is no ability for a U.S. order in any state to be provided an opportunity for enforcement. The Hague Abduction Convention is a reciprocal treaty, which of course means that both parties have to be signatories, have to have provided the responsibilities under the treaty and to afford those responsibilities. It is not a situation in which you can merely assert that the treaty is applicable whether or not there's actually been any type of treaty relationship. I need to point out that in the written remarks that you've been provided, there's reference, for example, to a number of countries and work on the part of the Department of State with respect to those issues. I have to caution that that information is inaccurate. In fact, Jamaica, Pakistan, and Tunisia have deposited their accessions with the Hague Conference, but their accessions have not been accepted by the United States Department of State. So there is no treaty relationship right now that exists with respect to those countries. With respect to Fiji, I agree that they reference it as having been welcomed the partner, but you should know that the accession was deposited in 1999 originally, and it's taken until now. And again, there could be very good reasons for the failure to accept the accession of a country that has indicated that they are filing it. In the prior testimony, you heard repeated reference to Japan acceding to the convention. So we are clear, Japan did not file letters of accession. Japan, once it ratified, became immediately effective. The United States had no oversight and there was no ability to accept the accession. Why that is important is that the idea that they would need some time to get up to speed, as you have heard, referenced that there was no way to place any conditions or to impact on the way the treaty was going to be applied in Japan. As I've testified in prior hearings, I was deeply concerned that Japan would ratify the treaty, and what would follow is exactly what we have, and that is, it is in name only. One of the most important aspects of the report has to be its accuracy and its transparency. If a country is listed as compliant, then a judge sitting in Washington State is going to look at the report and believe that a parent requesting the opportunity to visit that country will be doing so under an effective and existing mechanism for the return of the child. Without accurate information and accurate language, it creates the impression that there is a reciprocal, active relationship. Same with if we're talking about contexts of countries in which there are difficulties going on with their treaty partnership. There has to be transparency about where the difficulties are, even if it's a circumstance in which the State Department is reticent to list them as non-compliant. You still have to identify, oh, by the way, they're not going to enforce an order. They're not going to provide rights of access. You're not going to be able to have a child returned. That, to me, the unapologetic identification of actual issues in the report has got to be the number one issue that the United States Department of State does as it addresses and provides the information in this report. The second issue that was addressed and questions were asked that I think is extremely important is accurately describing what steps are being taken when you have identified that a country is non-compliant. There are a number of standard phrases that are found in the report that are not descriptive and not helpful. For example, talking about we're working with, we're talking with, we're trying to find practical solutions, we're working on educational opportunities are not responsive, very frankly, to the issues of the particular difficulties that you would find in a country. For example, if we were talking about a country where the problem is the enforcement of orders or the mutual recognition of orders, depending upon the nature of the problem, you might want to seek the entry of a mirror order in that country. So there are orders in both places before a child's permitted to visit. You might have additional passport and border restrictions that you would not otherwise have. There was reference in testimony to India. I think it's very important that this committee understand that India has taken a formal position against the execution of the treaty. There has been a study was commissioned in 2009. During the time period of that study, which took a number of years, most lawyers and judges supported the India joining the convention. However, the Indian government, when that issue was pressed and it was provided to public comment, strongly took the position that they believed, rightly or wrongly, that the treaty would not be a benefit to their citizens. In particular, it focused on the ability to permit, as they said, women to return to India without the necessity of having to respond or return children to their habitual residences. That's a formal position. It's not an educational problem at this point, especially given the length of time, which of course gets us to the systemic problem of diplomacy. There's a reference in the written remarks of the special advisor that is a little bit concerning, and that is a reference to diplomatic efforts. She indicates much of the day-to-day diplomatic engagement on abduction matters is handled by country officers in the Office of Children's Issues. There is no question that country officers work individual cases, but the Goldman Act was designed to go beyond the particular issue of any individual case and to broaden the concept of fighting child abduction by looking at diplomatic tools in an objective manner. The point is, as I've testified before, no individual parent should have to become, if you will, an officer of the United States Department of State and engaged on a state-level basis in determining what the problems are with compliance or reciprocity. I could not hear in the testimony, and I am unaware of any objective process that has been instituted by the United States Department of State with respect to any of the tools, as we've called them, addressing non-compliant countries. The last time I am aware of there having been any of actions like the tools that have been described were before this act was in place, and that was in the case of David Goldman, when, based on individual effort and effort of the chairman and effort of members of the Senate in addressing this issue, those elements were done from a congressional side. They were not recommended by the United States Department of State, and they were not supported by the United States Department of State. Nevertheless, they were incredibly effective in the return. When you have countries like we have had in the report since its inception that have remained on the non-compliant list, there has to be an objective process, and you have to have, as members of Congress, an objective report as to was a recommendation made that certain of these tools be employed. I mean, I didn't hear that there's even a process in place for OCI, Office of Children's Issues, to identify what steps they have taken and what the responses are, so that you can not only address the problems with respect to your constituents, but so that you can address in the committees in which you sit and the legislative determinations that you make whether or not that is a consideration you have to have available. In my discussions with attorneys and judges throughout the world who address these issues, particularly in countries that have been identified as non-compliant, they are almost unanimously in support of the concept that understanding that pressure will be placed upon the country on a systemic basis will make a difference in treaty compliance and will make a difference in looking at these issues seriously. With respect to, for example, the use of memorandums of understanding, they're ideal for the circumstances in which there is an educational issue. You can identify where are the problems, you can identify what actions have to be taken in what time frame, and until they are, you can then notify judges and lawyers in the United States that there does not currently exist a reciprocal treaty relationship. Again, when this act was originally addressed, the concern was that it would somehow tie the diplomatic hands of the United States Department of State. Well, to my knowledge, since this act has been enacted, other than a démarche, there has been no diplomatic action taken, no requests or any objective process employed or recommendations that I'm aware of for the imposition of any of the tools that you've identified. My final point that I would like to address is the issue of border control, and I do note that in the report that was provided by Ms. Lawrence, there's a reference to the Department of State working closely with U.S. Customs and Border Protection and referencing numbers. May I tell you that the number 200 children being enrolled in the program, Homeland Security's program, which is authorized by ICAPRA, is woefully low. We have had thousands of orders for protective measures. There are significant difficulties in getting families onto this list. The review process that's been employed with an extra step by the Department of State has been difficult. There has been a lack of communication back to judges as to whether or not children are on or off the list, creating an abduction risk. So that number is not a positive. 200 is woefully low. It evidences that there is a lack of implementation that needs to be looked at seriously. I'd be happy to take any of your questions or address any of the countries that are referenced with which I have experience that might be helpful.
Thank you, Chairman Smith and the committee members, for this opportunity to speak about Japan, Hague compliance, and my experience in the process, and I request that my written statements be entered into the record. When I last testified, it was last April before this committee, 2 months after Osaka High Court had revoked the return order of January 2016. In May 2017, I appealed this ruling, and in December 2017, the Japan Supreme Court ruled that the Osaka High Court was correct and affirmed the order and closed my case. A few weeks ago, the Osaka High Court canceled the previous enforcement orders and all penalties due to me, which grew to $132,000, $84,000 of which at the time when the Osaka High Court originally ruled and said that I had no financial means, they had already ordered $84,000 paid to me. This is how Japan executes the perfect Hague abduction. After over 2.5 years in this process, I have nothing. This process has cost me everything. Japan relitigated our Hague case as a successful ploy to avoid compliance with the Hague. The Hague is specific in its intended objective, a ruling to determine habitual residence and legal jurisdiction. That jurisdiction is the venue to evaluate a child's best interest in custody. Japan intentionally conflates Hague jurisdictional decisions as custody decisions, when Article 16 of the Hague explicitly prohibits custody determinations. The Osaka High Court's February ruling basically was a best interest custody hearing. For further details on this and other statements, please refer to my written testimony. Japan's court system is corrupt and must not be respected by the USA. There are groups and organizations that control much of the family law in Japan. Federation of Lawyers of Japan, whose members include Yoko Yoshida, Yuriko Nishimura, and Takayo Kamata, is one such group. Yoko Yoshida, vice chairman of the Committee on Gender Equality, an organ of the Federation of Lawyers of Japan, opposes Japan's ratification of the Hague Convention. Most of the attorneys who advise and help child abduction are communists, members of Japan Communist Party. See the written testimony for further details and evidence the communist attorneys' control of family courts and advocacy of abduction. A large piece of Japan's corrupt family court system is a network of governmentally funded domestic violence shelters, referred to as ShelterNet in Japan. An attorney, like Yoko Yoshida, will tell a woman seeking divorce and sole custody of her child to report to a DV shelter. The shelter will receive money for this woman and child. It is obvious this situation is ripe for collusion between Federation attorneys and ShelterNet member shelters. At the divorce hearing, applying the continuity principle, the judge rules the child is to remain with the abducting parent. An important point about the continuity principle: it's illegal. Civil Code 766 took effect in 2012, specifically instructs judges to use abduction against a parent in determining custody. There are no consequences for judges disregarding the law. Judges are rogue and create legislation from the bench. The jurisprudence of judges, even at the Japan Supreme Court in the Hague cases, even in Hague cases, is so-called continuity principle, whereby abductors keep children. We know this principle is operative based on the empirical evidence of many rulings, including my Supreme Court ruling of December 2017. Taking a child permanently from one parent is crazy and inhuman. More information on this issue is within my written testimony. As a result of Japan Supreme Court's non-compliant ruling of December 21st, 2017, on April 6th, I submitted, through legal counsel in Japan, a petition for impeachment to Japan's Diet of the following Supreme Court justices: Atsushi Yamaguchi, Masayuki Ikegami, Naoto Otani, who is now the Chief Justice of Japan Supreme Court, and his elevation has a curious, almost quid pro quo nature with relation to when my order or decision came out. Judge Hiroshi Koike, whose opinion at the end of my ruling illustrates at least one justice has a complete disconnect with the elements and the intention of the Hague. And finally, Katsuyuki Kizawa. The 52-page impeachment petition, plus supporting evidence, details illegal practices by the judiciary, collusion by attorneys, and ties to politicians in Japan's Diet, and details the several ways the Japan Supreme Court's decision 2017 ruling is in direct violation of the Hague. Such willful malpractice must only be resolved through impeachment. This petition is available to the 26 EU member countries, Canada and U.S. Department of State, to aid in their unified efforts against Japan regarding international parental child abduction. The original Japanese language petition is available from Kizuna Child Parent Reunion, an NGO in Japan. Japan must be held accountable. Diplomacy on this issue with Japan has not been successful for decades. More than 400 children, supported by DOS statistics, have been lost to U.S. parents in this time. Children are not bargaining chips or pawns because their rights are non-negotiable. For reasons outlined above, including the non-compliant Japan Supreme Court Hague ruling, Japan's corrupt judiciary, and Japan's unrepentant abduction practices, I recommend the following actions be taken. 1. Placement of indefinite tariffs upon strategic Japanese imports until the following occur. A. Revocation and invalidation of the Osaka High Court's February 2017 ruling and Japan Supreme Court's December 2017 ruling, and the immediate return of my 4 children without delay or condition. B. Criminalization of parental child abduction to Japan. C. Criminalization of denial of access to pre-Hague abducted children. D. Creation of a quick legal path to criminalization and prosecution of contempt of Hague return orders that include forcible arrest of abductor, prosecution of harboring individuals, and physical removal of children by law enforcement or the left-behind parent. E. Recognition and enforcement of all previous and future U.S. court custody and return orders. And F. Extradition of U.S. court-ordered persons by any means, including arrest, physical force, and arraignment of harboring individuals. Suggestion number 2. The Department of State to issue indefinite travel alert and caution to parents traveling to Japan with minor children of Japanese descent due to extreme abduction risk in Japan's history of non-compliance. This alert can be rescinded at some point when Japan shows 2 years of perfect Hague compliance. More recommendations are found in my written testimony. Finally, Japan has ignored démarches and similar toothless diplomatic efforts for years. Japan, at its core, is an economic nation that relies on asymmetric trade. That is, they sell far more than they buy. Effective strategies will use tactics that affect trade, not diplomatic talk. Tariffs, not talk. Deadlines, not debate. Progress, not promises. I ask this committee and fellow lawmakers to make laws as I have outlined above. I ask judges across the United States to heed my testimony when contemplating joint custody arrangements between U.S. and Japanese parents, and certainly any consideration of allowed travel out of the U.S. There is no such thing as a harmless vacation to Japan. I ask President Trump to make the call, write the executive order, or take the action that returns my children immediately. When you are with PM Abe next week, tell him he must do it, and he will. Please refer to my written testimony for recognition of groups and individuals who have helped. I'm not short on gratitude, but I am limited on time before this committee. Thank you again, Chairman Smith, and I am forever grateful for your years of work, these opportunities to speak, and most of all, I thank you for caring what you have.
Thank you, Mr. Cook. And I think your point about upcoming meetings with Mr. Abe is an excellent opportunity for the President to raise these issues. In previous meetings, we have given detailed memos to the White House in the hopes that he would raise it in a way that was significant and detailed. We'll do it again, so thank you. And your testimony, I can assure you, will be very clearly there, and hopefully as well as a summary of it that we will convey to he and others within the administration. These are great opportunities. Matter of fact, when in a previous meeting, obviously there's always been concerns about abductions from Japan to Pyongyang to North Korea, and the President has spoken out, as I have, and so many others have for years. Congressman Honda had a resolution years ago on that, and I was the Republican co-sponsor of it, believing that too is an egregious violation. Well, Japan itself needs to be held to account as well. So we did ask that he raise it with Abe. We will do it again, and I appreciate that. If I could, Mrs. Abe, if you could, when a judge is dealing with a case before him or her, do they read the report to get a sense of what that country's potential risks are? Do they often contact, for example, the State Department or the Office of Children's Issues to get a further delineation of how good or bad? Because the report is always dated, except for the first few weeks when it comes out, and even then, they might want to get an update if there's been any turn of events. How does that actually work?
Of course, as you mentioned, the report is retrospective in that it tells us about the numbers for the prior year, which is why the classifications of non-compliance versus compliance are so important, because it means you don't have to deconstruct what's happening yesterday. In most family court cases, of course, a judge doesn't do independent fact-finding. The information is presented to the court subject to the rules of evidence, which is why the report is so important. Because it's been generated by the United States Department of State, it can be taken, judicial notice can be taken of the content of the report, and it can be used then by the court in assessing risk, which places the burden on someone who is arguing that the classification of the Department of State should not be accepted. It places the burden on that person to come forward. So, for example, in a circumstance like Japan that we've been discussing, because Japan has heretofore not been listed as non-compliant, it places the burden on the parent who wishes to provide protections against travel in hiring an expert and having that expert come and testify specifically to the very issues that you've heard testimony on today. And I have served in that capacity. So the problem with that is, of course, it's an expensive process. It involves having to find an expert and to present that information to the court. And of course, the court is looking at a report issued by the Department of State saying that in the case of Japan, as we've been discussing, they're compliant. So it's extremely problematic. The court doesn't get, and wouldn't have the opportunity, as I said, to get updates, but the council can. And in fact, if on the State Department website and on other identifiable State Department sources of information, there are updated data, that would be something that the attorneys could reference and would look at, and in fact we do.
Let me just ask you on the necessity and efficacy of MOUs, which I know you have spoken to many times. We included it in the Goldman Act. I know prior to Japan's ascension to The Hague, the view from the State Department, not only for the Goldman Act itself, because the official position was against until it was reversed later by John Kerry. I didn't get any sense today that the department's any closer to pursuing an MOU with Japan or anyone else. What is this reluctance to find a durable, predictable means to resolve cases? Is it the effort that it resolves?
The Department of State took a position early on that they would not support any memorandums of understanding related to child abduction, on the theory that by setting up MOUs that they would somehow dilute the pressure upon countries to become signatories to the Hague Abduction Convention. What it misses, unfortunately, is the opportunity to use an MOU to address specific problems and to provide diplomatic solutions. So, for example, if you're talking about a convention signatory like Brazil, you could use an MOU to identify the areas that there are problems and then set objective goals, while at the same time saying, A, you're non-compliant, and B, until the following things happen, we're going to announce and make it clear that there is no reciprocal relationship, which means, for example, that American children would not be returned unless the treaty process was back in place. That's an example. The advantages of doing MOUs in non-Hague countries can be seen by, if we look at Pakistan, who has filed their accession. I'm looking forward. Hopefully the accession will be very soon accepted. Pakistan is one of the very only Sharia-based systems that's a common law system. We have high court judges prepared to apply the treaty. And part of the reason they're prepared is there's been a memorandum of understanding between Pakistan and the United Kingdom that has been working for a number of years, establishing the legal culture that allows now the treaty to become part of a normalized concept of the law there. That's an example when an MOU, especially when we have religious-based legal systems, can be used to bridge the culture so that we don't run into a problem where a country the accession is accepted and there's nothing in place. You have no underlying law, you have no underlying process, but you have on paper a reciprocal treaty agreement. I can only assume that the reason that MOUs haven't been used, now that you've got the numbers and the report that provides for them, is that there's just not been the diplomatic will to do the hard work to do that. And frankly, it's from my perspective, at least, I know that members of the bench and bar in the United States, members of organizations like the International Academy of Family Lawyers and the American Bar Association have been willing to work with the State Department as private practitioners providing technical assistance in drafting MOUs, in providing model orders, in doing things that would, if you will, advance the ball. Again, it's nowhere on the radar screen because there is no process employed for moving beyond a démarche. There's just, I don't see how the whole point of considering MOUs was to provide objective information so that we were not talking about speculative, subjective reviews of countries. We had objective information so that if we were talking to our friends, we could say, look, I'm sorry, we have a valued relationship with you, but the following numbers need to be addressed, and here's how. I just don't see that there's been the diplomatic will or the political will to do that on the executive side. And since I've been doing this for a very long time, I'm hopeful. Again, the work of this committee cannot be overstated in that when you look at the reduction and the preventative numbers, it's only because of the work of this committee. And it's made a huge impact on American families.
Suzanne Lawrence did talk about redoubling our efforts. We work tirelessly both in the U.S. and in our embassies. It seems to me that working tirelessly and redoubling our efforts says we're at the threshold now where MOUs should be given as a remedy as a means to a remedy of these cases. So we'll redouble our efforts to try to get them to do it, because I think it's just missing by a mile. Nice conversations, diplomatic meetings are all fine, but they should not be a substitute for a durable mechanism that can be employed with predictability and hopefully with success. But just a couple of final questions, and I deeply appreciate the subcommittee deeply appreciates both of your testimonies. It helps us to know what to do next and how to go forward, and I thank you for that. Ms. Appy, if you could maybe speak to countries that you have found to be more Hague compliant. Do you find that it's a problem worldwide, that everyone seems to have serious problems, or are there countries that you have found that really seem to be on the ball and really want to do the right thing? And again, if you could, Mr. Cook, I said it to Ms. Lawrence, you obviously said it in your testimony, but the whole idea that it seems to be missing, people say, what about Japan? Oh, we've brought some people back. Well, as you pointed out, when the abductor says no, enforcement ends. That is absolutely absurd to think that the veto power is vested in the abductor, the person who has committed this egregious action. So perhaps you might want to speak to that again, because I think the Japanese government needs to know that we find this outrageous. You cannot convey that kind of veto power to someone who has committed such a terrible act.
I would just reference on countries that are particularly successful. Keep in mind, of course, that the Hague Abduction Convention was executed in 1980. The United States ratified it in 1988. So for 8 years, a number of countries had already begun the process and begun the body of case law began to be established. And so you have, frankly, leadership in that regard. The United Kingdom, the Netherlands, Sweden, Canada would be places that have continued to apply the convention. I would note one common element to their success, however, And that is that in virtually all of those countries where the success rates are extremely high, left behind parents are provided support in having legal representatives to assist them in having their children returned. For example, in cases for Sweden, if a child is removed from Sweden to somewhere else in the world, the Swedish government assists in underwriting the costs of the return and the repatriation of those children. The result is that their numbers are far higher in the return of children. The same in the United Kingdom. There are particular judges that have been denominated as Hague judges. Legal aid is provided for left behind parents who are specialists in the issue of the Hague Abduction Convention. Of course, the United States took a reservation to that portion of the treaty that provided for assistance in legal services for the return of abducted children. And so members of the family bar throughout the United States, those of us who do this work, volunteer our time as pro bono lawyers, like the Elias case, keeping in mind that the average length of time for these cases, for treaty cases, run between 18 months and 2 years from beginning to end if they're successful. For non-treaty cases and treaties and countries that are non-compliant, non-reciprocal, the average is closer to 5 years. That's a long time to have to pay a lawyer. It's a long time to have to do travel and repatriation expenses. And the crippling impact of those resources cannot be overstated. In the Goldman case, there were over $250,000 of expenses in direct expenses that Mr. Goldman had to find and borrow and do whatever he could in order to accomplish the repatriation of his child. And it would not have been enough but for the assistance of the Congress of the United States in taking direct diplomatic action.
Okay.
I resemble that comment. I recognize that situation of having expending everything you have and it's still not enough. In fact, one of the recommendations I had is that the respective governments who sign the treaties are the ones that foot the bills for their respective citizens for this. So that way, I think I wrote, it'd be important for the State Department to have skin in the game. If they had to pay left behind parents such as myself all of the awarded penalties as a result of this, they might have a little bit different view on doing this. But with respect to your question or talking about permission to enforce in Japan, it is accurate to say that you need the consent, which is a little different than permission, consent of the abductor to have access to the left behind, to the stolen children. It's also, you need to have the consent of the abductor or those that are found guilty of abducting to comply with the order, because in Japan there is no contempt, or there is contempt, there are no consequences for contempt. So even though my children were ordered twice returned, my wife, he told me, was able to be in contempt for no consequence. Meanwhile, she accrued, as I said in one instance, $132,000 of per diem fines and enforcement fines that after the court had done its magic and flipped this order and revoked it, they then also, just like I said 2 weeks ago, took away any of the contempt fines. So I'm absolutely left with nothing. And this isn't just about me. This is how Japan operates, absent some external effort. And a little thing I wrote in here is when, we asked numbers of Ms. Lawrence about the returns of children. We keep pretty close tabs on each other, everybody in this community, okay? And the numbers that I'm told is that there have been now 7 total children returned to the United States. Of those 7, 3 of them were U.S. children returned to U.S. parents, none of which were done the result of Japanese enforcement powers because they don't have any. One was the death of the taking parent, the father in Japan, and so the child was reunited with the mother at the funeral. Another one, it was well, I can't use the words here. It was a mess of how that she reneged at the last second and chased the man out of the country, is the third. And then we have the case of 4 children. 4 children returned, Japanese children returned to a Japanese mother living in Oregon. Now we have another case that was just decided by 4 of the 5 Supreme Court justices that were in my case that just miraculously understood that alienated children's opinions should not be taken seriously, and being in contempt of a court order is a crime. So they're going to allow the possibility of this child to be returned to the left behind parent in the United States, who is also a Japanese citizen. So by using the State Department's own metrics, 5 of the 8 children returned under the Hague will be from one Japanese parent in Japan to a Japanese parent living in the United States. The Hague is not working for U.S. children. It's just an extension of the Japanese family law system. And our State Department does nothing about it. And I have dealt with Japan for over 30 years. And there is, we as people in the cause trying to get our children back have to battle through our State Department over into another land. And I believe there are forces within the State Department that are going to prevent, or are going to give a pass to Japan almost permanently, with the exception of someone like President Trump, or maybe the future Secretary of State stepping in and saying we're done. Anybody that, you know, we cannot allow Japan to continue to be non-compliant. These are children. I don't care what deals were done, what agreements were made, whoever they were sold out for, whatever donations to whatever foundations, we need to get these kids back. And it has to change. And whoever's left from that mindset needs to be blown out of the State Department. So we have people that actually follow the rule of law and follow particularly the Goldman Act. Because this is the only way we're going to get kids back, is to exert some sort of force upon Japan, some economic pain. Because at the end of the day, they're an economic country. They're excellent at the diplomatic rope-a-dope. They'll listen to you and they'll make promises all day long, and oh, they seem sincere. They're not. But they have to experience some pain. So.
Just one final question before going to Ms. J. Appel. India has been non-compliant pursuant to the Goldman Act and on the report since 2014. No penalty whatsoever. It seems to me this needs to be the year of getting the report accurate with regards to places like Japan, countries like Japan, and also a year of significant sanctions. What are your thoughts on that? Because again, a regimen that goes without, you know, it's all on paper and nobody does anything with it, it has a perverse outcome of countries saying it's a paper tiger. And this law was meant to be a game changer.
Well, and this is a good example of needing to look at the country we're talking about and identifying what the problem is to find a diplomatic remedy that matches it. In India, as I've mentioned, a significant portion of the judiciary and the lawyers, particularly in this area, support joining the Hague, support taking those steps, and there have been constant bar reports in support. The government has pushed back for political reasons and has indicated they will not do so. So,
does that have anything, if you don't mind me interrupting, to the fact that so many of those who are left behind are mothers or women? Because we've had testifying here a number of women who have had their children abducted to India.
The pushback was led by the Ministry of Women and Children, that indicated that they did not think that the treaty provided adequate protections and for women, and that they did not want that the return to, which was, again, considering the limitations of protection on women in India under Indian law, was sort of interesting to me. But focusing on the issue of India, we have a tremendous diaspora of Indian Americans, those of Indian descent in this country. There's regularly going back and forth. It actually covers the entire subcontinent. That's something where, for example, as you mentioned earlier, consideration of those issues in sanctions, whether it's dealing with visa issues, dealing with the circumstances under which someone can easily go back and forth, in circumstances in which we have a country that's going to, that's creating an environment where there is no ability to enforce U.S. orders, where there is an ongoing problem, where we do want to find a way to encourage them that to look at what their own judiciary and judges are saying needs to happen in their country. That might be one of the ways to creatively look at it. I would also say that this would lend itself to an MOU, identifying that we need to see these changes in this period of time. If you don't do that, then we're going to look at the circumstances under which we place our citizens at risk in going back and forth, and under what circumstances.
Thank you, Mr. Chairman. I am actually one of those Indians, people of Indian descent, and actually proud to be the first Indian American woman here in the U.S. House of Representatives. And so I'm looking forward to just understanding more about the situation with India. I think I know quite a bit about the treaty piece of it, but in terms of this specific issue, I just wanted to go back to what you said about other countries being more successful in negotiating for the return of some of these abducted children. Have you found that countries have had success with the very countries that we are having the most challenges with? For example, have other countries been successful at negotiating real resolutions with Japan?
My experience with Japan is that the rest of the countries that deal directly with Japan have the same problems we do. I've had a number of meetings with a consul general from representing other countries having these kinds of conversations, all of which I think would be led by and encouraged by joint activity in diplomatic activity, whether it's a joint MOU and signing onto a joint MOU, looking at identifying the problems and treaty reciprocity together, which is why it's so disheartening when you don't see the United States Department of State signing on with or joining in joint activity. So I would say my experience is, even with countries in the Pacific Rim, and there are challenges there throughout the Asia, but we have those issues. But we've got the real leverage. Yeah. Is the issue. We have status of forces agreements that we regularly negotiate. We're talking about a disproportionate number of our military members involved. We have the ability to take leadership in that area where we haven't. So in that context, I would say everyone's sort of in the same boat, but we have the best leverage to be able to address it. With respect to some of the other parts of the world, and particularly India, and Pakistan, I will tell you that the UK has had a significantly better opportunity of negotiating and working through some of these cases than we have. And they've been willing to, in some of these countries, enter into bilateral agreements that they work very hard in making sure work. And of course, as I mentioned, the government in that case provides a lot of skilled leadership in assisting those cases. Both on an individual negotiated basis as well as in assisting in litigation.
So you mentioned in your earlier testimony just sort of ways that we should clarify the language, in particular the categories within the report. What other, and Mr. Cook, thank you for your testimony. I just listened to you, and I don't have any words to express how this must feel for you and for other families. I've sat with Mr. Morehouse, and it's heartbreaking. So thank you for being here in spite of that. Just in terms of the specific recommendations of what we might push for, we can make amendments to the legislation. We could work on those pieces, but just in terms of immediate actions, that if you had the magic wand and you were in control of the State Department tomorrow, Ms. Happy, what would maybe just this portion of it.
Right.
What would you recommend that Congress do to push for those actions that you think would be most effective?
Well, first of all, I believe that there are adequate tools in this act as it's written. I do not believe that it needs to be amended. I think that the problem is that there has
You don't think that the report language should be clarified, or
I think that the act absolutely provides what should go in the report. I believe that the United States Department of State has to actually comply with the law as it's written, and I don't believe that they have enthusiastically been doing that, in the sense that they need to be, as I said, unapologetic, and they need to be objective. The language is already there. I would add, however, that I think that there needs to be an identified process for the circumstances under which they must move the diplomatic remedies that are provided in the Act from the lowest levels. When you have a country, I don't know whether it's the objective test, if a country has been in a non-compliance role for a year or 2 years, that at that point certain things have to be done. But I have to reiterate by saying a careful reading of the existing law provides the test for a non-compliant country. They're just not applying it.
Right.
And the existing law provides the circumstances under which you have to move to diplomatic sanctions, and they're not being done. So at some point, the mechanism is to come back and say, as was alluded to, do we have to then look at whether or not the State Department is accurately applying it, and if they're not, put additional steps in that force them to do that, which seems we have enough. The issues here are urgent. Time is not a neutral for these families. And the idea that there would be pushback when you've given the State Department an objective ladder that they can climb is extraordinarily frustrating. Pushing back at the 90-day report, for example. They have a 90-day report process. When the report first comes in and comments are made, they should come back with direct responses they're required to do under the Act as to what steps they've taken in individual country cases. They're just not doing it.
Thank you. I have nothing else. Yes, I yield.
And on that point, that's why we have had so many hearings. Not only to hear from left behind parents and experts like Patricia Appy, but also to try to hold them to account, to say, listen to the both spirit and letter of the law and just follow it. Which is why, again, this year we're having this hearing before the report is issued. We will have another afterwards, and then probably another one after that in this calendar year, just to keep the pressure on our own people just to do the right thing. And but thank you, it's a great question.
Thank you.
And I thank you both for your testimony and for your leadership. And Mr. Cook, know that our prayers and hopes are with you and other left behind parents. The hearing is adjourned.